यस
यस
सर
सर दिख
यस
रहा है।
सर दिख रहा है।
ठीक ठीक यस Good afternoon to all my dear friends. Today I have decided to discuss School of Mensria. As you know that we are discussing in the proper manner, and today after discussing the School of Mensria, I will start the first case which have been prescribed in your syllabus, which is the state of Maharashtra versus MS George, which was decided on 24th August 1964 by the full bench judgment. So what is the School of Mensria? Why I am discussing the School of Mensria before starting the MS George case? There is a reason behind this. Reason is that in the at the time of discussing the MS George case, whole arguments is depends upon whether the law is silent. Sorry, where the law is silent, whether mens rea should be impliedly accepted or rejected. So my point is that without understanding the school of mens rea, you can't understand the MS George case and subsequent cases. The here point is that there are two schools regarding the interpretation of the statutes in the context of the mens rea. These are these schools statutory provisions is silent. If the statutory provisions is not silent, then no question arises regarding these particular schools. Law must be, schools must be silent. As you know that with the help of this part, we can understand it. Statutes means enacted law. Whenever I use the word statutes means enacted laws. How to interpret the enacted laws? As you know that, for the example, we can take the example of the IPC. IPC is the enacted law. As you know that here the statute is clearly talks about mens rea. Here the statutes, some sections talks about clearly mens rea. For the example, whenever you read section 299, wording is that whoever with the intention of causing death, with the intention of whoever does an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that by such act it is likely to cause death commit the offense of culpable homicide. So my point is that whenever you will read the 299, you can clearly get actus reus as well as mens rea. So my point is that, for example, whoever does an act means actus reus with the intention of causing of death. Intention is the mens rea. The my point is that in 299, actus reus non facitorium nisi mens rea had been clearly mentioned, clearly discussed. Okay, but here there are some sections in which law is silent about the guilty mind. Law is silent about the guilty mind. For example, if you read the section 375, which is related to the rape, be careful. I am not knowing anyone prior to taking the class. In the offline, I can't understand what do you think about me. But point is that I am teacher of the criminal law. I will teach each and everything. I believe that all of you have completed the graduations and you have mature mindset. That's why here there is no personal ego, no personal disputes. Whatever I will discuss only for better understanding for all of you. And be careful, once you make a complaint regarding whatever you say, that it directly affects me, and at time of teaching it creates always something extra pressures. So that's why be careful. So my point is that here if you read the section 375, at time of reading the section 375 you will read that nothing has been said about the guilty mind of the accused. As you know that no one have dared to say that 375 talks about these points, but you can say, you can read, I will teach later on. The my point is that, for the example, 375 or 121 or 494, if you read these particular sections, you will find that law is silent about the guilty mind of the accused. Okay, the my point is that in such law, here the actus reus, okay, about the actus reus, law is clear, but regarding the mens rea, law is silent. Regarding the mens rea, law is silent. Question arises, whether if the law is silent, mens rea can be presumed to exist or mens rea can be presumed to be absence. The point is that here the how to interpret such provisions. Such provisions means those provisions where the statute is silent about the guilty mind. There are two theories. There are, as you know, that at least 1,000 judgments have been discussed, and near about in 500 judgments it had been mentioned that if the law is silent about the guilty mind, it must be presumed that mens rea is a part of the statutes. It means where the law is silent, actus non facit reum nisi mens rea should be applied. Okay, but at least 500 judges are just opposing. They are saying that no, 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 no. If the law is silent, you can't insert such condition. You can't say that mens rea is also necessary. So my point is that there is a hard debate between both the sides. One side, judges saying that if the law is silent, if law is silent, judges must insert condition of mens rea. Other sides judges say that no, if the law is silent, you can't insert condition of the mens rea. So my point is that here the two parts, presumption of the existence of mens rea. Among them, I will discuss 10 judgments in which 5 judgments are related to the where the law is silent, presumption must be existence. 5 judges I will discuss regarding on these points where the law is absence, what judges can't insert mens rea as a new condition. On these points here, the regarding the MS George case, MS George case is on these points. MS George case which have been prescribed in your syllabus on these points. It means in the MS George case, there is a one statutes. In one statutes was silent about the guilty mind. Judges, there were 3 judges. One side, 2 judges. 2 judges were Justice Iyengar and one more. He was saying that if the law is silent, person must be convicted even without guilty mind. This is the majority judgment. But on the other side, in the MH George case, Justice Subbarao said that if the law is silent, about the guilty mind, if the statute name of the statute was FERA, Foreign Exchange Regulation Act, if the FERA is silent about the guilty mind, in that situation, maxim actus non facit rea must be applied. ठीक है, कंप्लेन अपनी जगह पर है. तुम बताओ कि अगर नहीं समझ में आया तो थोड़ा सा हिंदी में समझा दूं. ऐसा कोई
नहीं सर, कैन यू रिपीट वंस मोर टाइम?
बताओ, हिंदी में बोल दूं अंग्रेजी में बोल दूं?
सर हिंदी में भी समझा सकते हो.
हाँ, चाहे
हिंदी में बोल दीजिए, थोड़ा प्रॉब्लम होता है हिंदी मीडियम वालों को.
यस थोड़ा बहुत चलेगा. Be careful, I am not going to teach anything in new things in the Hindi, whatever is that common. हिंदी में इसका ये पॉइंट है कि जैसे मान लीजिए कि कोई कानून बन गया, तो कानून के जैसे मान लीजिए आईपीसी में 511 सेक्शन है, तो 511 सेक्शन को हम 2 पार्ट में डिवाइड कर सकते हैं. 2 पार्ट में डिवाइड हम कर सकते हैं. एक पार्ट वो है जिसमें कि सीधा सीधा निकल करके आता है कि व्यक्ति का एक्टिविटी भी होनी चाहिए और वह एक्टिविटी गिल्टी माइंड के साथ किया जाना चाहिए. जैसे कि 299 सेक्शन जब आप पढ़ेंगे, मर्डर के डिफिनीशन दिया गया है, इसमें साफ साफ लिखा गया है कि कोई भी व्यक्ति दूसरे को किल करना चाहिए, उसका डेथ काज करना चाहिए, लेकिन उसी सेक्शन में लिखा हुआ है कि वह डेथ व्यक्ति के इंटेंशन के साथ होना चाहिए. अगर कोई भी व्यक्ति किसी का डेथ काज कर दिया लेकिन गलती से हो गया, एक्सीडेंटल हो गया, मिस्टेक से हो गया, तो वह अपराध नहीं होगा. क्यों? क्योंकि 299 में एक्टस रियस भी होना चाहिए और मेंस रिया होना चाहिए. यह लॉ में ही लिख दिया गया, 299 में ही लिख दिया गया है. तो यहाँ पे जजों के पास कोई ऑप्शन नहीं है. जजों के बीच में कोई फाइटिंग नहीं है, इसमें जजों के पास कोई डिस्क्रेशन भी नहीं है। लेकिन दूसरे कैटेगरी के कुछ सेक्शन ऐसे भी हैं जो सीधा सीधा कहते हैं कि व्यक्ति ने कोई काम किया है, जैसे मान लीजिए वेजिंग वार, भारत सरकार के खिलाफ आपने युद्ध छेड़ दिया। अब युद्ध में कई बार ऐसा होता है कोई जानबूझकर पार्टिसिपेट करता है, कोई अनजाने में भी पार्टिसिपेट कर देता है। आपको पता ही नहीं चलता है कि हम जिस भीड़ में जा रहे हैं, जिस भीड़ का हम समर्थन करने जा रहे हैं, उसका नेचर क्या है। कई बार ऐसा गलती हो जाती है। तो अब मान लीजिए कि किसी व्यक्ति ने गलती से ऐसा कर दिया, भीड़ जा रही थी, भीड़ के साथ ही साथ चल दिया, उसके खिलाफ वेजिंग वार का एक्शन लिया गया। अब जब वेजिंग वार का एक्शन लिया गया कि वो जब भीड़ जब जा रही थी सरकार के खिलाफ, तो वह व्यक्ति उसका पार्ट था, उस व्यक्ति का अब मेंटल कंडीशन पे साइलेंट है। लॉ 121A नहीं कहता है कि वह व्यक्ति जानबूझ करके जा रहा हो, वह व्यक्ति इंटेंशन से जा रहा हो, नॉलेज से जा रहा हो, इस बात पे साइलेंट है। सिर्फ 121 ये कह रहा है कि वह वेजिंग वार में था, इन्वॉल्व था। अब गिल्टी माइंड के साथ था या नहीं था। अब एक दो व्यक्ति हैं, एक व्यक्ति जानबूझ करके जा रहा था, उसका मैटर एक अलग हो गया। जो व्यक्ति इनोसेंट था, इनोसेंट जा रहा था, उसके साथ क्या किया जाए, उसका कन्विक्शन किया जाए या उसको रिलीफ दे दिया जाए। मान लीजिए कि इसमें हम किसी बच्चे का नाम मान लीजिए ले लेते हैं, दिखाई दे भाई, सरोज। मान लीजिए सरोज एक व्यक्ति है, वह इन्वॉल्व है इस व्यक्ति में, लेकिन गिल्टी माइंड नहीं है उसका। वो कह रहा है कि भाई मैं इनोसेंट हूं, मैं इस तरह के जान ही नहीं रहा था, मैं तो ऐसे ही चला गया, इनोसेंट हूं। अब इनोसेंट होने के बावजूद अब उस व्यक्ति का कन्विक्शन किया जाए या न किया जाए। अब इसमें जजों का दो ओपिनियन है। अब कुछ जजेस कहते हैं कि नहीं, वेजिंग वार बहुत ही सीरियस मैटर है, व्यक्ति चाहे इंटेंशन के साथ जाए, नॉलेज के साथ जाए, या विदाउट इंटेंशन या विदाउट नॉलेज के जाए, इससे कोई फर्क नहीं पड़ता, उसका कन्विक्शन होना चाहिए। दूसरे साइड में जजेस कहते हैं कि नहीं नहीं, ऐसा नहीं होना चाहिए। कई बार इनोसेंट आदमी, भोला भाला आदमी भी इस तरह के अपराधों का पार्ट हो जाता है। जब लॉ ही साइलेंट है तो आप मेंस रिया को एक्सेप्ट कर सकते हैं, इस मैक्सिम को अप्लाई कर सकते हैं और इस व्यक्ति को रिलीज कर दिया जाए, रिलीफ कर दिया जाए। मतलब हियर देयर इज अ फाइट, इफ द लॉ इज साइलेंट देयर इज अ फाइट बिटवीन वेदर द presumption of existence of mens rea should be applied or not. For the example, in one case, in the MS George versus State of Maharashtra versus MS George, he was a jurist, he was a smuggler, he was from the Germany. He went to India with how many gold? 34 kg gold. Once he came India, he was arrested. I will discuss thoroughly, but in the brief for time being. He was arrested and he took the plea. Millards, I was not knowing that keeping so much gold in India is prohibited. I was innocent. Question arises that, okay, he was the innocent, but he was not knowing about Indian law, whether he must be punished or not. There was fight between three judges. Two judges were one side and one judge was other side. Justice Subbarao was in this side. Justice Iyengar and other judge was in this side. It means two judges were in this side, one judge was in this side. Person was convicted even without guilty mind, because two judges was saying that here in such cases person must be convicted even without guilty mind, because object of the statute says that smuggling must be prevented. So my point is that these are the fights, these are the schools which I will proceed further and I will discuss further. Okay, come to the point. As you know that here there are some cases. In these cases it was observed that if the statute is silent, presumption of existence must be followed. For example, Fowler versus Fazet, Telstarson, Siraj, Brand, Nathula. Here the name of the judges. Here you can find the chronology. I never write without the chronology. On the other side, presumption of absence of the mens rea. If the law is silent, in these 5 cases it was observed that if law is silent, mens rea can't be inserted as a condition for conviction that person. It means 5 judges or 6 judges on one side and 5 judges on the other sides. These are the 10 judges I have to discuss. I hope that all of you have understand these points and be careful. These questions, presumptions, arise only in those questions where the statute is silent. If the statute is clear, then no question arises regarding the presumption of existence or absence of mens rea. Come to the facts. As you know that some questions had been asked in our semester exam, difference between intention, knowledge, motive. As you know that I have shortage of time and I have written, you can read yourself. There is no need to discuss these points. Come to the direct case. Here you can read motive, intention, knowledge. As you know that in the morning, I added some question paper which had been asked in the judicial service exam. From where you can see the here question paper of the judicial exam. In the Rajasthan Judicial Service, question was that distinguish between knowledge, intention, motive. In the Rajasthan Judicial Intention, whose mic is on, please off. Okay. Be careful. Don't video on and mic on. Sorry, each and everything off. Here the question is that distinguish between knowledge, intention, motive. Distinguish between intention, motive. Discuss the strict liability. I had already discussed earlier. Earlier I discussed the case what is the actus non facet reum nisi mens rea and discuss its exceptions. I had already discussed. What is the meaning of mens rea? Explain the dictum actus non facet reum nisi mens rea. Write short note difference between knowledge intentions like this point. If you go to in the UP judiciary, in each and every year, there is a one questions which had been asked based on the first topics. Okay, that is the intention, knowledge, etc. If you go to the semester exam, in the semester exam, question had also been asked in this way. So my point is that at least one question had been asked regarding the differences between intention, knowledge, and motive. You can read yourself. There is not much more. As you know that we have to complete within shortage of time. But at least read yourself. If you are unable to, for example, here in the brief, here the intention, if you can see the intention. Intention means two elements. What is the intention? If there is two conditions, both the conditions are sine qua non. Sine qua non means which is necessary, which is the part and parcel. To desire of consequences as well as foresight of consequences. Desire of consequences and foresight of consequences. Desire of consequences, suppose that it is my desire to kill you. This is desire. But foresight of consequences, I know the range of my gun. That is the foresight of the consequences. I know the range of my gun. If both the conditions are together, that will be called intentions. As you know that in the criminal law, there is a big difference between intention and knowledge. Wherever intention had been written, please read the intentions, use the intentions. If you at a time of discussing the culpable homicide, I will say that if the death had been caused with intention, if death had been caused with intention, you may be hanged till death. Okay, but if it has been caused with the knowledge, then offense nature of the punishment will be something different. It means later on I will. It is the very important. Intention means desire plus foresight of consequences. Intention word had not been defined in the IPC, but this is the perfect definition of this. Knowledge. In the knowledge, there is only one element, that is the foresight of the consequences. It means anyone asks what is the difference between intention and knowledge. You can say that in the intention there is a desire of consequences. जैसे मैं आपको kill करता हूँ, I want to kill you, I want to steal these things, I want to harass you. This is the desire. But I know by which behavior I can harass you, by which behavior I can kill you. These are called the foresight of the consequences. Okay. Here the knowledge, in the knowledge there is only one consequences. There is only one condition. Foresight of the consequences. Several times a person although do that work with the knowledge, even though he is not convicted. For the example, I want to take example. For the example, in section 92 of the IPC, there is one example, one illustrations had been quoted. Suppose that there is a house. In the house, fire had caught, and one children is stringent in that house. मतलब एक मतलब in that house one baby, मतलब sorry for that, there is a house. In that house there is a baby. Unfortunately, caught fire in that house, and that baby is at the 4th floor. Everywhere is fire. What happened? One person went, but he had no option except to throw out the baby. And at the ground, everyone with the some cover, everyone with some seats, and they are ready to catch that baby into that seat. He knows, that person knows that if he will throw, and persons who are trying to catch that baby felt that baby can die, but even with this knowledge he threw out. And what happened? That baby, uh, persons can't hold that baby, and subsequently that baby died. Whether he had committed any offense? Answer is that no, he had not committed any offense, although he was doing with the knowledge. इसका मतलब ये है कि कुछ मैटर ऐसे हैं जहां पर कि आप नॉलेज के साथ करेंगे और काम गलत भी हो जाएगा तो भी आपको सजा नहीं मिलेगी। क्यों? क्योंकि आपका डिजायर उसमें नहीं है। क्या है आपके पास? सिर्फ और सिर्फ फोरसाइट है। जैसे मान लीजिए कि एक घर है, एक घर में आग लग जाती है, एक छोटा सा बेबी घर में फंस जाता है, सबको चारों तरफ आग लगी हुई है, सबको मालूम है कि बेबी को बचाया नहीं जा सकता। अचानक के फायर ब्रिगेड का आदमी या कोई भी व्यक्ति ऊपर चढ़ जाता है, लेकिन उस व्यक्ति को मालूम है कि अगर मैं नीचे लेकर के आऊंगा सीढ़ी के साथ तो ये व्यक्ति जल जाएगा, ये छोटा सा बेबी जल जाएगा, मर जाएगा। उसके पास कोई ऑप्शन नहीं होता है, लेकिन नीचे खड़े हुए व्यक्ति नीचे से चिल्लाते हैं कि तुम फेंको, हम लोग चादर लिए हुए हैं, सीट लिए हुए हैं, इसको फैलाए हुए हैं, तुम फेंको बेबी को, बेबी इसी में गिरेगा और हम लोग बेबी को बचा लेंगे। अब वह व्यक्ति का इंटेंशन है, वो सोचता, वो सॉरी उसको नॉलेज है कि मैं बच्चे को फेंकूंगा, फोरसाइट ऑफ कॉन्सिक्वेंसेस, तो नीचे गिरेगा और मर जाएगा, लेकिन उस व्यक्ति के पास डिजायर नहीं है कि नहीं मैं इसको नीचे फेंकूं और ये व्यक्ति मर जाए। व्यक्ति को बच्चे को मारना नहीं चाहता, उसको बच्चे को मारने का डिजायर नहीं है, लेकिन उसको नॉलेज है कि अगर ये व्यक्ति नहीं बचा तो यह मर सकता है, और उस व्यक्ति ने उस बच्चे को बचाने के पर्पज से नीचे फेंकता है, और नीचे के लोग उस बच्चे को नहीं पकड़ पाते हैं, सेव नहीं कर पाते हैं, और वह बच्चा गिरा और मर गया। अब आप बताइए कि वेदर ही हैड कमिटेड द क्राइम, वेदर ही हैड कमिटेड दैट एक्टिविटी विथ इंटेंशन or with the knowledge? The answer will be that that person had committed with knowledge rather than intention, because in the intention desire and foresight both must be, but in that problem there was a foresight but there was no desire to kill that baby, so there was a knowledge, there was no intention, so he had not committed any offense. So my point is that in some cases if you are doing that work with knowledge you will not be punished, but in some cases if you are doing that activity with knowledge even without intention you can be punished. For example, there is a terrorist, there is a person who is carrying the bomb in the bus. He knows that unfortunately if bomb blast in the bus everyone may kill, but his desire is that to blast at the parliament. So desire क्या था? His desire was to blast at the parliament, but he knows at a time of journey that unfortunately if the bomb blast in the bus every person may die, even though he must be punished for the murder. So my point is that intention, knowledge, both are totally different things, both never should be mingled to each other. Anyone questions? Intention, knowledge?
No, sir.
Okay, thanks. These are the points regarding the motive. You can also read. Here I have made the differences between both. You can
Sir,
hear. Yes,
sir, so in case of terrorist, whether it will be considered a crime,
yes.
but the intention and desire is different then too.
My point is that intention and desire both are different things. Certain times, what happened? Suppose that there is a terrorist. His desire is to make bomb blast at the parliament. His desire is to kill head of the country. His desire is to kill the president. वो प्रेसिडेंट को ही मारना चाहता है
Yes, sir.
लेकिन इंटेंशन क्या है प्रेसिडेंट को मारने का इंटेंशन में दोनों चीज है डिजायर भी है कि वो प्रेसिडेंट को मारना चाहता है और नॉलेज भी है कि हाँ इस सॉरी फोरसाइट भी है कि बम ब्लास्ट करने से प्रेसिडेंट मर सकता है ठीक लेकिन जो आसपास के लोग वहां पे खड़े हैं जो भीड़ इकट्ठा हो रखी है प्रेसिडेंट को देखने के लिए मिलने के लिए उसको उसको मारने का इंटेंशन नहीं है कई बार ऐसा होता है ना कि एक ही व्यक्ति को मैं मारना चाहता हूँ लेकिन उसको फिर भी मालूम है कि अगर ब्लास्ट होगा तो आसपास के लोग भी मरेंगे जबकि उनको मारना नहीं चाहता है तो जब वो प्रेसिडेंट को मारने के लिए जा रहा है तो प्रेसिडेंट के मार को बम ब्लास्ट करते समय प्रेसिडेंट के मामले में इंटेंशन है बाकी व्यक्ति के मामले में उसका नॉलेज है और एक बात और है ऐसा कभी मत सोचिए कि व्यक्ति के पास नॉलेज है तो उसका पनिशमेंट नहीं होगा सिर्फ इंटेंशन के मामले में ही पनिशमेंट होगा ऐसा नहीं होगा सेक्शन 92 कुछ सरकमस्टांसेस बता रहा है कुछ एक्सेप्शन बता रहा है कि जहां पर आप नॉलेज के साथ करने के बावजूद भी आपको रिलीफ मिलता है दैट इज द डिफरेंट थिंग्स ओके तो बी
Okay,
क्लियर
sir.
culpable homicide and murder may be committed in certain circumstances with intention in certain circumstances with knowledge if you want to write you can divide the 299 in two parts class 299 part A part B with the intention second part 299C with the knowledge 300
Your screen is not visible.
oh अभी वो किया नहीं था okay it is visual
Yes, sir.
yes in 300 you can divide there are four and there are four part of the 300 part A part B part C intention part 4 knowledge so my point is that only difference is that if offense is committed with the intention gravity of punishment will be something more but there are certain exceptional cases in which if the activity had been done with the knowledge that activity would not be an offense for example a doctor at a time of making the surgery he knows the consequences that in case of failure of the this operation he may die but what is the desire of that person's whether doctor want to kill patient no his desire to save it means he was his intention was in that case his desire was nothing there was only a foresight of the consequences in the case of the doctor my point is that in certain cases knowledge को दो पार्ट में डिवाइड कर देते हैं knowledge there are two parts in certain circumstances if act is done with the knowledge person will be punished for example 299 300 there are certain cases when the activity is done but that is not offense no punishment for example if it is act with section 89 or section 92 in such cases even act is done with the knowledge there is no punishment but in such cases a person is committed with intention it is the punishment okay in case of intention in each and every cases there is the punishment okay this is the difference here you can read here there are further definitions you can read yourself come to the point here Come to the state of Maharashtra versus MS George. This is the first case which have been prescribed in your case material. Let us start this particular case. As you know that this case was decided on the 24th of August 1964. This case was decided by full bench. Full bench means 3 judges. Name of the case is State of Maharashtra versus MS George. What happened? You have to know the facts of this particular case. In this case, MS George, Mayor Hans George, was a German smuggler. What was his qualification? His qualification was he was the smuggler. From which country he belongs? He belongs from the Germany. One day he left Zurich. Zurich is the famous city of the Switzerland. You can see here there is a pic, Zurich airport. He left the Zurich by plane. वीडियो माइक आप ऑफ कर लिया करिए आप लोग, ठीक ना? कोई बोल देता हूँ तो आप लोग कहते हो बुरा लग जाता है, तो अपने आप ध्यान रखा करो. So my point is that he was a German smuggler. He left the Zurich. Zurich is a famous city of the Switzerland. What happened? On which particular date he left? He left on the 27th November 1962. With 34 kilos gold concealed on his persons to be delivered in Manila. Final delivery of that gold was Manila. But what happened? The plane arrived in Bombay on 28th November in the early morning. In the early morning, it means plane was Zurich to Bombay, Bombay to Manila. He left the Zurich on 27th November 1962. How much kg? 34 kg of gold, concealing in persons. And his intention was to go to the Manila. He arrived at Bombay airport on 20th November, but the respondent did not come out of the plane. I need some corrections. Respondent should not be here. MS George, it will be better, or he, but he is the better. As you know that I always write that way something different. He, I have to say it. He, correction. But he did not come out of the plane. The custom authorities examined the manifest of the aircraft to see if any gold was consigned by any passenger. As you know that there was a manifestation, whatever is that, there was a register. Bombay police tried to search the name of any person who is carrying the gold, but in that register, name of no one was mentioned. It means according to the register, according to the Bombay register, no one was carrying the gold. That's why to confirm whether any person is smuggling gold or not, those authorities entered into the plane and they recovered the gold from the MS George. And they charged him under this particular section of the FERA Act. It means on record, MS George had never informed to the Indian authority that he was carrying 34 kg gold. So when he was examined, authority recovered 34 kg gold from him. And he was prosecuted under FERA Act, which was in contrary to the notification issued by the RBI. The point is that which statutory provisions are involved in this particular case? In this particular case, Foreign Exchange Regulation Act, RBI notifications dated 8th November, published on the 24th November 1964. Main important fact in this case was that before some days, RBI had prohibited such smuggling. RBI had issued some guidelines and he was not knowing these guidelines. In the brief, important places you can find out here. Important place is the Germany, Zurich, Bombay, Manila. There are 4 cities are important to understand the facts of this case. Germany, smuggler was the citizen of the Germany. Zurich, George left Zurich to Manila. Matlab, it means smuggler went to Manila, and from the Manila, he came to India, and final destination was Manila. George left to Zurich to Manila. He was arrested where he was arrested? Arrested at Bombay. Manila was his final destination, but before reaching to final destination, he was arrested. Important date in this case. In this case, 24th November 1962. Just before 3 days, RBI had published a notification under the FERA Act, Foreign Exchange Regulation Act, and it had clearly prohibited carrying of such gold without informing the proper authorities. 27th November, on this particular date, George left Zurich to Manila. 28th November, George was arrested at 6 a.m. at early morning. On 24th August 1964, this is the date of the judgment of the Supreme Court. George was convicted by the Supreme Court. As you know that this is the final, I will argue, I will take 1 or 2 classes on this particular case, but as you know that this is the basic idea. Without basic knowledge, without basic facts, you can't understand. Because all of you are beginners in the field of the law. What was the purpose of the act? As you know that we are talking about the Foreign Exchange Regulation Act. Purpose of this act was to prevent the smuggling of gold, to converge foreign exchange, to prevent national economy of country, to protect the national economy of country. This was the purpose of the case. Okay, this is the brief fact of this particular case. Now I will start arguments on both the sides. Okay, now I argued on behalf of the respondent, on behalf of the state of MS and on behalf of state of Maharashtra. As you know that everyone knows that liars knows only for the arguments, and both the sides liar will give some arguments. So that's why in the field of law, everyone must aware about the arguments of both the parties. So this is the brief fact. If anyone have confusion, this is the Bombay airport. If anyone has confusion regarding this fact, please let me know. Otherwise, I will start the arguments from both the sides.
Excuse me, sir.
Yes.
Sir, I have a doubt.
Yes, please ask.
Sir, applications of IPC पढ़ते वक्त IPC कहाँ वैलिड होता है, उस पॉइंट में एरोप्लेन का ये रूल होता है कि जिस कंट्री में एरोप्लेन रजिस्टर्ड होती है उस कंट्री का लॉ लगता है. सर फैक्ट्स में ये लिखा है कि ही डिड नॉट कम आउट ऑफ द प्लेन. तो सर ऐसे नहीं होना चाहिए था कि अगर वो प्लेन से बाहर नहीं निकला तो इंडिया की उस पे मुकदमा ना हो.
ऐसा है ना, एक बार उसको फिर से पढ़ना.
ओके सर.
हाँ, एक बार उसको फिर से तुम पढ़ना, टेरिटोरियल जुरिडिक्शन पढ़ना आईपीसी का.
हाँ जी सर. ठीक
ना. हाँ, उसको एक बार फिर से पढ़ना, अगर नहीं समझ में आएगा तो बता दूंगा.
ओके, थैंक यू सर.
हाँ, एक सेक्शन 1 2 3 4 तक पढ़ना है. सिर्फ सेक्शन 1 2 3 4 चारों सेक्शन पढ़ लेना, ठीक ना.
ओके सर.
तब क्लियर होगा इसमें.
थैंक यू.
ओके.
हाँ जी सर.
I want to start arguments on both the sides. As you know that this is the very popular and landmark judgment of the Supreme Court till now. As you know, that's why we should know much more about arguments on both the sides. As you know that in this case, what was the point? I already told you that he was carrying the 34 kg gold. He was not the small baby. It means he was much more bigger. He was very big person. He was very rich person. And he arranged several reputed liars. And on the other sides, government was also much more curious because this was a matter of the 34 kg gold. It was not matter of 10 gram gold, 1 kg gold. It was matter of 34 kg gold. It means both the parties wanted to win the case. That's why both the parties made several arguments from both the sides. And making arguments on both the sides, several previous judgments were quoted from both the sides. So here I will discuss at least 5 judgments which were quoted, which were discussed, which were cited on behalf of the MS George case, and at least I will discuss 5 or 6 cases which were argued on behalf of the state of Maharashtra. It means there was a huge fighting between both the parties. How fighting between the liars, among the liars, not with the physical fightings. Fighting is here means arguments, how much they argued to each others. Okay, to come to the argument. Here in the arguments, I will take help of some cases. Fowler versus Fazet, Prince, Towson, Siraj, Hobbs, Brand, Indo, Ranjit cases. These are the cases which you have to know about what was observed in these particular cases. As you know that from the very beginning, in this case what happened, first of all know the fact. In this case, much more point was that section 23(1)(a) of the Foreign Exchange Regulation Act. Which act? Section 3 of which particular act? Foreign Exchange Regulation Act. Was silent about guilty mind. Was silent about mens rea. As you know that I told you that when school will be applicable only in those cases where the law is silent about guilty mind. If law is clear about the guilty mind, then there will be no problem. Then no question arises regarding presumption of existence of mens rea or absence of mens rea. So my point is that here our law covers FERA, F-E-R-A. Here FERA Act covers under this particular part. Okay, Foreign Exchange Regulation Act covers under this part. In this part, section 23(a) of this particular act was silent about the mens rea. Question arises with it was proved by the MS George. He clearly proved that, Millards, I left Zurich on 27th November. RBI had issued notification just before 3 days. That's why I was not aware about the notification of the RBI. ये कहता है कि Millards, I left the Zurich on 27th November. While Indian law had been changed just before 3 days, how it was possible to read and remember in few seconds in so much shortage of time? That's why he totally proved that, Millards, I am innocent. Now question arises whether MS George can be convicted even without guilty mind. What was the issue? Issue was that whether MS George can be convicted even without guilty mind. This was the issue. In this case, arguments were cited on both the sides. First of all, I want to give at least एक मिनट टाइम लगेगा थोड़ा सा दोनों साइड में अब आते हैं. Here these are the arguments on behalf of the MS George. These cases were cited on behalf of the MS George. Do you know, before 3 years, there was a student who was very extraordinary student, who was familiar, still familiar. He always come at my home. He told me, sir, you never discussed thoroughly MS George case with the help of cases. He complained me. And later on, I realized that Up to some extent, because he was a student, he was right. Do you know, earlier I was teaching with first of all these cases. Then I had started the MS George cases. But now at present time, before 2 years, I had changed way of my teaching. Now first of all, I discuss the facts of the case and start the arguments of these cases. Because once you open the case made, reasoning of all these cases you will find. So my point is that these cases were cited on behalf of the MS George case. So my point is that in next time, don't complain, sir, you did not discuss MS George case thoroughly. No, even these cases are part of the MS George case, except this case, sorry, except Nathulal versus State of Madras case, because it was later on discussed. These 4 cases are part of the MS George case. It was argument on behalf of the MS George. But on behalf of the state, these cases were cited on behalf of the state. State argued on behalf of these cases. Majority opinion upheld this. In the majority opinion, which was written by the Iyengar, he clearly said that on the basis of these laws, it can be concluded that person can be convicted even without guilty mind. Minority opinion was written on these bases. Honorable Justice Subbarao said that this particular law FERA must also be discussed in the light of these cases, and MS George should not be convicted. MS George should not be punished because he was guilty mind. But as you know that minority opinion always prevails, majority opinion always prevails over the minority opinion. The crux is that he was convicted for causing the under the section under the FERA Act, Foreign Exchange Regulation Act. Tomorrow I will start the arguments from both the sides. Time हो गया है, मेरे 2 minutes is remaining. Okay. In the next class, 2 minutes बचा है ना? हाँ. In the next class, I will discuss the R versus Prince and other cases. Are you free in the next class?
No, sir.
Okay.
No, sir.
Okay, ठीक है. I want to take a screenshot. Please on your video, each and every one. Yes.